Hello, everyone. I have 2:16 on my clock, so I hope everyone is ready to jump back in to the Board of Psychology meeting. Ms. Pruteau, can you please call the roll?
Kasuga.
Here.
Fu. Oh, great. He's not here. Harpsheets.
Here.
Phillips.
Here.
Rescate.
Here.
Rogers.
Here.
Tate.
Here.
Roll is complete.
Thank you. And hanging on to a quorum. We're going to jump right back in to agenda item number 4, B2. Mr. Polk, can you walk us through it?
Yes, thank you. This is an action item. The action requested for board members to review the proposed bill language and consider a position on the bill. Assembly Bill 883 proposes that boards under the Department of Consumer Affairs expedite the initial licensure process for an applicant who supplies satisfactory evidence to the board that the applicant is enrolled in the U.S. Department of Defense Skill Bridge program. The Skill Bridge program allows service members to gain civilian experience through specific industry training, apprenticeships, or internships during the last 180 days of their service. On February 23rd, the bill was amended to add clarifying language to state the applicant who supplies the satisfactory evidence is an active duty of the regular component of the Armed Forces of the United States, and the board may adopt regulations necessary to administer the expedite. On March 28th, the bill was referred to the Assembly Business and Professions Committee, which passed with the 18 yes votes and 0 no votes, and it has been re-referred to the Assembly Committee on Appropriations. At this time, I'm open for comments or questions.
Hi, Mr. Polk. I have a question. Do we have any groups that we do any expedited paperwork for?
Yes, currently we expedite military applicants and spouses of military applicants as well.
Okay, thank you for clarifying.
Yes.
I see Dr. Phillips, you have your hand up.
Thank you, Dr. Tate. Mr. Polk, so this is simply a question of expediting. It's not a question of changing requirements for licensure, correct?
That's correct. Yeah, this is just in regards to expediting current military members who are also enrolled in the Skill Bridge program.
Okay. I have a question for Ms. Sorek then. Ms. Sorek, do you would this be the type of thing we normally would take a support or oppose position on?
I think in the past, when there have been issues about different qualifications for licensure or application fees, we have communicated those concerns to the author. This is not, the staff doesn't have any recommendation on this, but the board may want to convey one position or another in support of this or what have you.
That's useful. I'd like to take a motion that the board take a position of supporting the legislation. Do we have a second?
I'll second that. And this is Leah Tate. Is there any other board comment? I'm scrolling slowly. Okay, I'm seeing Dr. Phillips, is your hand up or is it the lazy hand?
Lazy hand.
Got it. Thank you. I don't see any board comment, so let's open it up for public comment. Mr. Moderator, please.
We are now accepting public comment on the matter. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of the screen and send that comment to all participants. Dial-in users, please dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take a few seconds now to see if we have a request for public comment. Seeing no request for public comment, do you wish to return to the agenda or the
Yes,
motion?
please. And thank you so much. Opening it up to the board for any other comments before the vote. Seeing no hands. Ms. Pruteau, can you please call the roll?
Kasuga.
Aye.
Fu. Hardsheets. Hello? Hello, can you hear me?
We can hear you.
We can hear you.
Okay, sorry about that. I'm not sure what happened, but my speaker seems to have cut out. Okay, so Kasuga, Hardsheets.
Oh, sorry. Okay. I'm here.
Was that an I?
Yes, yes, sorry.
Thank you. Phillips.
Aye.
Oh,
We may have just lost you. Say
Yeah.
something else, please.
Okay.
You're very faint at the moment. Well, we heard Phillips, and then we haven't heard the next one.
Can you hear me now?
Much
Yes.
better.
Okay, great. Riscate.
Aye. Aye. I think I heard you, Miss Purteau.
Thank you. Tate.
aye. Thank you so much, Ms. Pruteau. Motion passes. We are moving on to item 4B3, AB 996. Mr. Polk?
Yes, thank you. This is also an action item which requests board members review the proposed bill language and consider a position. Assembly Bill 996 proposes that boards under the Department of Consumer Affairs develop and maintain a conflict of interest policy that would discourage the qualifications of any continuing education course if the provider of that course has an economic interest in a commercial product or enterprise directly or indirectly promoted in that course. On March 27th, the bill was amended to clarify the sections order, not the language, just the sections in which the language is provided. On March 28th, the bill was set for the first hearing in the Assembly Business and Professions Committee. However, it was canceled at the author's request, and at this time, another hearing date has not been presented. I'm open for any questions or comments at this time.
Hi, Mr. Polk. Thank you so much for presenting this item. The way I read this, it feels like I'm missing details. It's not specific enough for me. Because it reads, if a psychologist wrote a book and was presenting on a class and the book is for sale at that event, that's what this would be addressing. Is that correct? For example?
Yes. Unfortunately, yeah, this bill's language doesn't provide clear, detailed language. We have reached out to the author's office to get the clarification and get like a fact sheet that would provide the problem that this is hoping to solve. But unfortunately, we haven't received any additional information or clarification from the author's office.
Okay, thank you. They obviously had something in mind when they wrote it. I just don't know what it is.
Right.
Let's see, I see a hand up. Dr. Kasuga.
What comes to mind for me when it comes to this bill proposal is, for instance, if let's say someone like wrote an assessment, for instance, like, you know, the author of the ADOS cannot get CEs for the ADOS training or something like that. Is that something that makes sense to others? As with regards an example of what this particular bill entails?
Dr. Phillips, you have a hand up too.
Yeah, I think there's some situations where this is clear, and it's probably more true in the medical setting, where, for instance, somebody has a consulting contract with, I don't know, my office is in Beverly Hills, so I'll go with Botox, and then gives a continuing education course on how to administer Botox. In psychology, it's a little less clear. So, for instance, using the example that Ms. Kasuga had given, if somebody had developed a test and was going to present a class on how they normed the test, how it should be administered, how it should be interpreted, etc., that would be of great interest, I think, and would be worthy of CE. Mr. Polk, is the suggestion that the board needs to create conflict of interest regulations, or is it that we should create regulations that outlaw any such activity?
My understanding of the bill is that it would require the board to develop and maintain a conflict of interest policy that would discourage any continuing education course if there's a conflict of interest with the provider having some type of commercial or enterprise within the course itself, whether that's directly included or indirectly. Just unfortunately, like I said, with trying to get clarification on exactly what this bill is proposing, we've been kind of falling short of that from the author's office.
Yeah. I mean, I'm not sure it makes sense in all situations, simply that there's some conflict of interest relative to commercial enterprise. I understand the point behind it, but I don't think it's specific enough for us to really be determined whether it's an appropriate bill or not. So
There definitely isn't a lot of information.
Yeah.
Ms. Sorick?
I just want to point out one additional point. In our discussions on the bill, we were talking about our continuing education providers, and some of those are at the national level. This conflict of interest policy would require us to make sure the national organizations like ACCME are in compliance with our California State Board of Psychology conflict of interest policy. And just looking at the practicality of implementing that law is pretty unlikely.
Thanks, Ms. Sorak. Any other? Oh, let me see. Is that Ms. Halbo?
Yes. If you have a national provider, you've got sort of a tail wagging the dog situation, because there are 50 other, 49 other states, and you may or may not be able to get the information. Also, if it does have to be done for every course, or can the board certify that it's passed these conflict of interest things and revisit it every 5 years? Because there's a lot of this is going to be expensive for the board to try to enforce this law, and in some cases unwieldy if it's a national organization that is not responding to inquiries. That's all.
Thank you. Dr. Phillips, do you have another comment?
Yeah, I do. I make a motion we oppose this for its non-specificity and kind of elaborate some of these points that we're raising.
I
second.
To the author.
I second. This is Dr. Hardsheets.
I hear you. Thank you. We have a motion by Dr. Phillips and a second by Dr. Hardsheets. Any other board comment before I open up public comment? Okay, I'm seeing no. Oh, Ms. Sorick.
Just wondering if, aside from the motion on the table, if Dr. Phillips would be open to having a review of a draft of the letter before it is.
I would be overjoyed to have an opportunity to review a draft of the letter.
Great. Thank you.
Thank you. Mr. Moderator, can you please open up public comment?
We are now accepting public comment on the motion. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of the screen and send that comment to all participants. Dial-in users, please dial *3 to raise your hand, and we will call on people in the order we have requests. And the first hand I see is from Sheila Henderson. Hold on just a moment. I'm going to send you a request to unmute your microphone.
You hear me?
Yes, go ahead, please.
So I was surprised by this because I recently attended a conference and there were books being sold by the presenters that I was really excited about both to see and purchased because I felt that it would make me a better psychologist to have access to them. And also, I would say that writing a book on something really enhances a presenter's ability to think through what they're teaching or what they're offering. And I just can't imagine why it's a problem that they sell their book either there or on Amazon as opposed to giving it away for free, which we know that would just dramatically reduce the number of books sold. So maybe I've misunderstood, but also if an organization that's offering a conference on a topic is, say, has organized themselves as a for-profit versus nonprofit, but still offer something of value to psychologists to do better work, I don't see why that would be a problem. So I'm as you guys have indicated, I'm also confused, but don't know what the purpose of this legislation would be, and it seems overly restrictive for the livelihoods of psychologists who are offering services to the rest of us. That's it.
Thank you.
I'll just mute myself now.
Wonderful, thank you. Next we have Jolinder Crow, who will be followed by Dr. Amuz. All right, bear with us just a second. I've got to find you on the list, Jolinder Crow. Thank you for raising your hand.
Hi, everyone. Jolinder Crow with the California Psychological Association. I just want to offer this little bit of information, and this is yes, it's a very non-specific bill, and we are also trying to get more details. There are two parts to it that I'm curious about and that we are going to try and find out. The first point is that if this turns out to be a requirement that someone have a conflict of interest form or something that you sign, that is something that's very common. A conflict of interest is not always a bad thing. Not disclosing a conflict of interest is a bad thing. And so that's one of the questions I have for Assemblymember Lowe. The second piece is related to what Ms. Sorick is talking about. The Board of Psychology in California does not review courses and does not approve sponsors. The Board of Psychology has in the regs recognition of those of us who are approved by the national organization, or in our case, also approve providers at the state level. In the APA sponsor approval guidelines, there already are requirements related to conflict of interest that we have to abide by to maintain our approval from APA. And we have those same kinds of requirements in our criteria when organizations apply to the California Psychological Association to be approved. So I think it really goes to the issue of when I see this kind of bill, I'm wondering what the genesis of it is and what problem it's trying to solve. But I would agree that this would be, it seems hugely complicated to me in the if it were to go through like this and the implementation phase. I don't, it looks to us as if the bill is not moving very well. And so but I did want to offer that perspective of the sponsor approval systems that you have said are acceptable, ACCME, APA, all of those national approval bodies, conflict of interest and the requirements around that are always a strong part of the criteria that we have to follow.
All right, thank you. I'm going to put you on mute, and next will be Dr. Imuz. Hold on just a moment.
Yes, can you hear me?
Yes, go ahead, please.
Dr. Marilyn Imos from CDCR. I've long sat on a committee where we have mainly medical providers from our organization or from outside organizations who are presenting continuing education accredited from the CMA CMEs. And we have this question, we all have to sign this document, but basically, as somebody, I just wanted to reiterate this, already mentioned, it doesn't necessarily preclude someone from being able to get CMEs for a specific educational activity. It's simply a piece of information if there's a conflict of interest. And I think the most common one type that I've seen over the years are owning stocks in a medication that they're now presenting in a training. So that this applies more actually to our medical counterparts than it does to psychologists. I too have taken courses in specific psychological tests, standardized tests from test authors, and feel that this is very important, but it's something else. If, it requires a signature, I don't see why the Board of Psychology would be involved in this, as Dr. Jo Linder-Crowe was saying. It is APA or the CMA as far as I can see, but if I'm understanding this incorrectly, please correct me. Thank you.
Thank you. And we're going to take one last look around. Those are all the requests we have for public comment at the moment. Do you wish to return to the motion?
Yes, thank you so much. We have a motion and a second. Are any last board comments at this time? I'm doing a very slow scroll. Do not see any hands. Ms. Pruteau, can you please call the roll?
Just wanted to confirm that you can hear me.
Yes.
Okay, great. Kasuga.
Aye.
Harb Sheets.
Aye.
Phillips.
Aye.
Rascate.
Aye.
Rogers.
Aye.
Tate.
Aye.
Thank you.
Thank you. Motion passes. We'll just continue on to agenda item 4B4, SB 372. Mr. Polk.
All right, thank you. This is an action item. The action requested for board members to review the bill analysis and amended bill language and consider a position on the bill. Senate Bill 372 would require each licensing board under the Department of Consumer Affairs to update a licensee or registrant's legal name and or gender when the board receives government issued documentation. The bill would prohibit the board from charging a higher fee for reissuing a document with a corrected or updated legal name and/or gender than the fee that's currently charged. On March 20th of this year, the bill was amended to include for licensees and registrants that are changing name and/or gender, the board would be required to remove the former name and/or gender from the online license verification system and treat the former name and/or gender as confidential or private information. The board would also be required to establish a process to allow a person to submit a request to retain the now private or confidential information. On March 27th, the bill was referred to the Senate Business and Professions and Economic Development Committee, which passed with 8 yes votes and 2 no votes, and was re-referred to the Committee on Judiciary and set for a hearing on April 18th. I'm open for questions or comments at this time.
Thank you so much for presenting this item. I have a lot of questions about this, but initially, Ms. Sorek, can you outline how this would affect board staff and our process if we had to implement the name and gender changes and allowing the former name and gender as confidential?
So right now, when you go to license verification and you look up an individual license name, that information in the Breeze online licensing system will populate with any record of that individual. If they were a registered psychological associate, before they were a psychologist, and the standing of each of those registrations and or a license. With this bill, if someone were to, and the bill right now as it's written doesn't necessarily specify that it has to be a gender change. It is a name change the way it is written. So anyone that were to change their name could make their prior license or registration history confidential. So a consumer would not be able to go online and access that information. That would require a change in the Breeze system, which would impact the way the bill's written, the medical board, the Board of Behavioral Sciences, and the Board of Psychology, which would be a change in the system, which would be associated with a particular cost. And I don't remember what that exact cost is. I think it might be in the analysis. But that would be the change there. Does that answer your question?
Yes, thank you so much.
Sure.
I see that Dr. Harp-Sheets has your hand up.
Thank you. My question is, I'm thinking from a consumer standpoint, if I am wanting to see a particular psychologist and I look that person up, I'm savvy enough to look them up. And if that person, let's say, has had a disciplinary action under a different name than the name they're currently using, I would not get that information. And that's a worry for me from a consumer protection standpoint. So, and if I think I heard Mr. Polk saying, or somebody saying, that this bill would not require that their name be, well, it does say it would require that their name be updated. But anyway, okay, so I'll go back. I think that's a worry for me. That there wouldn't be a trail in terms of a name change.
Thanks for your comment, Dr. Harp-Sheets. Dr. Phillips.
Yeah, I shared Dr. Harp-Sheets' concern. I also share the following concern. If a consumer, for instance, had worked with somebody 5 years ago and has decided to go back into treatment or needs their psychological records for one reason or another, they wouldn't be able to identify how to contact the prior therapist who's now changed their name. I'd be more comfortable with this bill because of the potential for harassment and discrimination and all the untoward effects on trans people. If there was a specific carve out for trans people and there was a mechanism for consumers to still be able to ask somehow the system for information as to a past therapist. And I don't know quite how that would work, whether it would require a special request from the licensing board, or if the dead names could be disassociated from the current name. I do find the idea, though, that somebody's disciplinary record wouldn't transfer with them in the system as problematic.
Thanks, Dr. Phillips. Both you and Dr. Harpsheets are bringing up my concerns. So coming from a consumer protection standpoint, it's hard to conceptualize someone trying to find a therapist and can't locate them. Ms. Riscate.
I echo the same comments that have already been made. But my question was, so if you can't see the previous information, does that mean their license number will also be changed? Because wouldn't you still have the option? Don't you continuously have a license number? So if we were able to just change their name, why wouldn't we be able to see the same information if their license number is not changing?
Ms. Chung, can you maybe speak to how that might work in the system?
Yes, thank you, Mr. Scate. So on the DCA license search, you could search by a license number. So there are several search functions that you could use, or search criteria. You can either go by name or license number. So if you know of a licensee's or registrant's number, you can definitely search by that. I hope that answers your questions.
It's still kind of like because the comment was made that if their name was changed, then you wouldn't be able to see past information, cases, or disciplinary action that was made on that person. So if you can look up the license number, so you would be able to still see the past disciplinary actions and anything.
If you know the license number, and I would say.
Don't. I'm sorry, this is John Burke, the Assistant Executive Officer. I believe the bill is written, it wouldn't be. It would change the name retroactively as well, I believe it would require. So if you put in the license number and the person had changed their name, the historical name would be altered too, I believe, is my understanding of the bill. And as you've all mentioned, that becomes a big... there's no issue of someone changing their name and still being searchable and seeing the historic name. That's what we have now, and we process them all the time. The issue is the desire to change it, going back into the past, and for the removal of documents with the old name, because that for us causes concerns with discipline. It's really cases with discipline that we've not come up with a good way of how best to administer this to satisfy the will behind the bill. So that's what I've just, so if you knew the license number and search that in, it would only come up with the new name, not the old one, as the bill is written.
And Mr. Burke, it would not come up with a disciplinary record, is that correct?
No, I don't believe so. I think we would have to disconnect anything that linked the old name with the new name. And right.
That's what I was thinking. If the discipline showed the old name, even if it transferred over to the new name,
that could be problematic under the bill. It wouldn't be allowed.
They wouldn't have access to that information unless we've, redacted every disciplinary case where this came up.
Well, that's another, yes, that's a possibility, the redacting it, but there can still be other information in there. I don't see there'd be any way to change the name because, obviously these are legal documents that have been signed. I don't think that would be possible. So So yeah, that's the issue. That's the issue we see in terms of the administration.
So I have Dr. Oh, go ahead.
Oh, I was just going to ask real quick, Ms. Ng, if this would be immune from the Public Records Act request. So if someone were to ask us for the information and it wasn't readily available, would there still be a process by which they could get the records of the dead name and the license or registration history?
I think as the bill is written, it specifically says that the licensee or registrant's former name and gender shall be deemed confidential. So there's certainly an argument to be made that this information will be protected from the Public Records Act, but it's beyond that statement in there. I don't know that it's been addressed, but I can certainly see the argument being made. And that's in section 27.5 sub A sub 2. The licensee's or registrant's former name and gender shall be deemed confidential.
I see Dr. Kasuga's hand and Mr. Fu.
Thank you, Dr. Tate. I just wanted to kind of like express the same concerns as everybody with regards if someone is trying to look for information about a particular licensee, because as from my experience, most people don't know exactly the license number of their particular psychologist. And most of the time what they do is they look at Breeze, and that's how they enter their name, and that's how they find the license number, not the other way around, even though, like, yes, we provide business cards with our license number and all that. But it just like would pose barriers for the consumer who's trying to look up a particular licensee, because it seems like it's the other way around. You kind of like know their name and then you look for their license number, as opposed to having the license number like accessible to you, and then just like, it's easy to find out what their new name is now, or like what their like the information from, like previous names may change, but the license number stays the same. So I think that's a concern. And then I echo like everything that I think that it really makes it difficult for us for consumers to find their a particular licensee, and it's hard for us as a board to implement this, even though it says that we're also supposed to be required to establish a process to allow a person to request and obtain the information upon request. So I think the implementation of that may be challenging for us as a board.
Thanks, Dr. Kasuga. Mr. Fu?
Thanks so much. I really appreciate the conversation we're having here, and I just wanted to say at the outset that I think the goals of making sure that a person, particularly a person who's transgender, is not traumatized through subsequent government processes. I think that strongly resonates with me, and I'm concerned about the fact that the records wouldn't follow the individual in some form, right? And so I think my questions are more on the administration side of things, where my understanding, and I will defer to whomever can answer questions about Breeze and the technology behind it, but how often do we make modifications to the Breeze system to make it comply with whatever goals a board or boards may have in response to legislation or regulations?
I will defer to Ms. Chung on this one because we usually have an ongoing list working with DCA on either legislative mandate changes or operative changes that staff has identified that we request through DCA.
Thank you both. I do have my licensing and breeze coordinator here, Ms. Song. If we have more questions, if you need more details, we can definitely loop her in as well. So from my understanding, that the department is on like a sprint release, kind of like a monthly release regarding any changes that we have submitted. So, of course, if legislative regulatory changes, there's a timeline there for when they need to be effective. Those would take priority in the corresponding release. So in order for those new changes to be in place for the effective date, whether it's like a legislative mandate or a regulatory change. Of course, we will have to build in time before, like advanced time before the effective date to provide all the necessary information to the department wonderful breeze team to make these changes.
And Ms. Chung, so it sounds to me that the current concerns about like having the prior record with what is known as the dead name or any information affiliated with that dead name is a product of the current breeze system we have, but not necessarily of a breeze system that we could have depending on our conversations with the vendor. Is that correct?
I think because the bill language kind of, I want to say kind of broad because, the board has mentioned some of the issues regarding the documentations that were attached or being displayed along with those names. So the technicality there probably may need a conversation with vendor. We're not sure. We have to really ask the breeze team to see what can be done or what options there, how to make that work.
That's really helpful. And I think my last question here is I would be really interested in terms of a conversation, not as a board member participating in these conversations, but as the board staff is in conversations with the vendor, I would be interested in understanding if there's a world where we're able to carry the previous discipline record by just saying that under California, as in accordance with SB 373, there's a prior disciplinary record related to this type of violation, gross negligence, et cetera, et cetera. Please contact the board for further questions with regard, if you have any questions. I'm just curious to see what the capacity of the system is to be able to recognize that there's importance in making sure that the discipline record is being carried over with the individual, and also still trying to be respectful of any changes that they've made in terms of their personal lives. And so would just be curious when you have a conversation with the vendor, what the capacity of the technology is to be customizable enough to accommodate a world where you can have both consumer protection and also respecting the rights of a trans individual. And that's all for me. Thank you.
Any other board comment? I see Ms. Sorick. I see your hands up. Is that an old hand or a new hand?
Hi, new hand. Just kind of following the conversation, and I wanted to draw the board and the members of the public's attention to, in the meeting materials, is included the analysis from the BMP committee. And this included, I believe, some kind of technical input from the department. And I will draw your attention to, on the combined packet, it's page 127, the bottom. It's going to be number 4. And this I just want to highlight this for your awareness or draw your attention to it for those on the call. So it says, while this bill outlines the requirement for certain action by DCA licensing entities that receive a request related to a complaint against the individual, it's not clear how members of the public would be able to automatically access information about enforcement actions taken against a licensee if any documentation, including their prior name, is no longer connected to the licensee in the public-facing portion of the online licensing system. The legislature has passed numerous measures aimed at shining a light on the actions of licensees to ensure the public is able to be informed about not only the qualifications and licensure of an individual, but also any discipline that the individual has faced throughout the course of their licensure. For many DCA licensing entities, complaints are not public, and members of the public are not aware of enforcement action until legal proceedings have commenced. A member of the public may not know to search for an individual by name to ensure they are in fact licensed, but then separately engage the individual's licensing entity about prior disciplinary action taken against the same individual with an old name. The author should continue working with DCA, and the bill may need to be amended to ensure that any licensing entity's process to provide disciplinary action information to an inquiring member of the public is related to enforcement action rather than just a complaint. The bill may need to be amended to specify that within the process, reference to the prior name may need to be redacted in order to achieve the goal of preventing the individual's association with their prior name. It may also be clearer for the individual to simply receive a new license number to ensure that their profile is publicly searchable and available only with their new name. And part of the licensing entity process that is developed for providing disciplinary action on the individual under any old name could include the entity's steps, if statutorily necessary, to clarify to connect the two licenses at the licensing entity's level. So I hope that doesn't confuse anything, but I just wanted to make sure to point out that piece because there were some questions about implementation.
Are there any other questions? Dr. Kasuga?
I just wanted to make a comment that I appreciate Ms. Sorik's clarification with regards implementation, and I think that definitely changes have to be made to the bill, and if there's a way that a link, even if it's just within the board and not visible to the public, with regards the old name and then the new name, just for enforcement purposes, then that might be, like a good way to achieve both, as what Mr. Fu is trying to figure out if there's a possibility in terms of implementation. But it seems like the bill as it stands doesn't include that. Is that correct, Ms. Sorik?
Based on the conversation today, the tenor that I'm observing is that while the intent and the purpose behind the bill is laudable, that it's in the details where there are the most concerns. Access to the available patient records. If a patient, wants to get their records, how do they connect with the individual if they don't know the license number? So making that, accessible to the user end. And then with the disciplinary action, which may be less of an issue because, as you all know, our licensed population is about 4 to 5% that get formal discipline. So what we're talking about here is more of the access to the individual and their information. So if they wanted to get their patient records or they wanted to look up the history of the person as a licensee or registrant, that was transparent and available. I'm also wanting to make sure to point out that the language as it's written now is more inclusive of kind of anyone with a name change and not just individuals that are going through a gender change. So if the discussion is going in a particular direction, I would just want to make sure that that part is highlighted, that it should be specified what population we're talking about here instead of anyone that has a name change. So I just wanted to add that. I don't know if I'm hoping that answers your question.
Thank you, Ms. Sorek. It's primarily just like trying to understand all the ways that this bill would impact implementation and access to the information for our consumers, whether it's for enforcement or to request their patient records. And I think that your clarification helps us have a further understanding of the scope of all the changes that this bill may impact, not just for our trans licensees, but also for like everyone who could potentially change their name, and the lack of distinction currently as to both.
Thank you, Dr. Kasuga. Mr. Fu.
Thank you, Madam President. Ms. Sorek, I'm curious on your last comment. I think what I'm hearing from you is that, and please correct me if I'm misunderstanding, is that there's a concern that a person let's take a second to just suspend our thoughts on with regard to the gender identity piece, which I think is the inspiration for this bill. But I think what I'm hearing from you is that you could see a scenario where a person has discipline and is seeking to remove that discipline from public records for whatever reason, and will use this process of seeking a name change to be able to have their disciplinary record purged. Is that what I'm hearing in terms of your last comment?
The way the language is written now, having it be so broad, that would allow for someone to abuse that process.
Understood. That's really helpful to hear, and I think and one thing that I'm balancing is that I think the name change process that is articulated here is would have to go through a filing in court where a judge would then have to provide a court order that provides your new legal name to then change their name on identity documents, driver's license, passports, and social security card. And if I recall the process or understood the process correctly, it would be, I think at most a $450 filing fee, and then a 2 to 3 month review period with the judge. And then the judge will make the decision through a court order. And so I think for me, the question that I'm wrestling with is, to the extent which a person who's seeking to abuse the process, what is the probability of and the risk of such a person who doesn't want to see a probation or doesn't want to necessarily see a revocation on their record, where they would then go through the process of changing their entire life through administratively through at least a 3-month process with a court order, and then subsequent documents related to their Social Security and whatnot. And I'm just trying to weigh like how much a person would have to be motivated if it's not in relation to their gender identity to do that. So I'm just naming that aloud as we consider who would abuse this process if it wasn't necessarily because of gender identity, but because they were seeking to somehow suppress their former disciplinary record. And that's all. Thank you.
This is Brittany. To your point, Mr. Fu, the way the language is written, it would also encompass folks who just had a name change. For example, if maybe they changed their name when they got married, it would cover that swath of people too. So even if not intentionally trying to abuse the system, people who've had their name changed in that situation would automatically fall in under this too. So maybe not intentional, but still are repercussions in terms of people trying to find individuals who've gone through that process too. I think that just kind of speaks to how broadly the language is written and not necessarily just affecting those people who might seek to abuse the system.
Thank you. Dr. Phillips, I see your hand is up.
Yeah, I was just going to say, obviously it'd be an unusual situation where somebody goes through a name change to lose their disciplinary record. But if your disciplinary record is haunting you, and one maneuver you can make is to get out from underneath your disciplinary record, or at least public knowledge of your disciplinary record, doesn't strike me as being that far-fetched that somebody who perhaps is not the most honorable practitioner might go about the process of making a name change. And as Ms. had pointed out, if you get divorced, if you get married, I mean, there's a variety of different ways that your name could end up getting changed, and they're all kind of subsumed by this legislation. So in my mind, the legislation needs to be much more specific, and I think it would really need to address the mechanism by which consumers would still be able to have access to contact information and past discipline as it relates to people who are going through some gender confirmation process. And by the way, we use the word gender change. I think that's considered fairly objectionable now. I think it's really more talk about gender confirmation. So we may want to consider that in our future use of language.
Thank you, Dr. Phillips. Was there a motion in there somewhere?
Sure. I make a motion that we oppose this legislation and both laud the purpose of the legislation and enumerate the number of ways in which we think this is problematic. Is there a second?
I second it, Dr. Hardsheets.
So there is a motion and a second. Any other board comment before I open it up for public comment? I'm seeing no hands. Dr. Phillips, is that the lazy hand again? Thank you. Mr. Moderator, can you please open up public comment?
We are now open for public comment. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of the screen and send that comment to all participants. Dial-in users, please dial *3 to raise your hand, and we will call on people in the order we have requests. And the first request for comment that I see, Jennifer Alley. Hold on just one moment. We're sending you a request to unmute your microphone.
I'm Director of Government Affairs for the California Psychological Association, and we're, proud to be co-sponsoring this bill with multiple behavioral health provider types. And we have the California Association of Marriage and Family Therapists, licensed professional clinical counselors, 2 organizations representing psychiatrists, the California Community Behavioral Health Agency in support, and some other groups. And so, we came together to do this bill primarily for our license types, and were advised by legislative staff to make sure that this bill include all of the boards under the Department of Consumer Affairs because of the high rate of discrimination, harassment, loss of employment opportunities, and just overall discrimination for individuals going through a gender conforming change. It's very evident to the provider groups that are supporting this bill that the re-traumatization of these individuals is unfortunate, unacceptable, and doesn't reflect the values of our society. We are in constant communication with our legislative author's office and committee staff to address a lot of the concerns that have been raised in this thoughtful conversation by the board. But we do not want this process of protecting not just gender conforming individuals, but also victims of domestic violence who may legally change their name, who don't want to be associated with their former name, not to diminish consumer protections or to have former complaint or enforcement action be removed from that licensee's number. And so how that process works is complicated. There are 3 boards in the state that currently do this. For example, the state bar, if somebody does a search on a former legal name that's been identified to be private, they're prompted to call the state bar, and then their questions are answered and information is provided. And so we're working with the Department of Consumer Affairs. Currently, we're going to be up in the Senate Judiciary Committee on the 18th. And we're working with that committee to address a lot of the issues that are coming forward. But we really feel that this bill is critical and important in today's society. And it really is a grassroots bill that bubbled up from our membership after years of asking for us to move forward with this. We think it's really, really important. And so we would, respectfully ask for you to reconsider your opposed recommendation or motion that's been made for those reasons. And I just wanted to add that it is our understanding and our intent for this bill to apply to individuals with legal name changes that request the information to be kept confidential, not for every single individual that has a legal name change. For example, somebody who got married or something or divorced. And so if that is not clear to you, then that is something that I'll definitely take back to the coalition that's working on this bill. And I'm happy and available to answer any questions that you may have. And I thank you for the opportunity to speak with you today.
Thank you very much. And I do not see any other requests for comments at the moment. Wait, I take that back. Dr. Winkleman, hold on just a moment. We're going to send you a request to unmute your microphone.
Hi, Dr. Elizabeth Winkleman again with the California Psychological Association. I wanted to follow up on Ms. Alley's comments, just to mention that and to the discussion of the board, that the bill does specifically foresee that there will be provisions, and it's in the bill language of there will be provisions to ensure that consumers could find the information or file a complaint under the licensee's previous name. So we were very well aware of this being a consumer protection issue, and the idea is being that it would just not be automatically pop up on the Breeze search, but that the Breeze system and the boards would develop procedures that such information can be requested and can be accessed, but that it would not automatically pop up on a search. And as Ms. Alley mentioned, this came up from constituents, and there's been a lot of support for it from people who have been harassed and lost jobs because somebody looked them up and determined that and found out that they had changed their name and changed their gender. So that's where it's coming from, and the plan is to implement, and the specific legislative language is to implement it with consideration of there will be a mechanism to obtain information on licensees who have changed their name when requested. Thank you.
Thank you.
Ms. Winkleman, can I ask you a question?
Sure.
Is the intention for it to just revolve around name change as opposed to gender conforming or gender confirmation?
It's regarding, I'm pretty sure, and maybe someone else who's looking at the law right now can correct me. I believe that is for any legal name or gender change that it can be requested to be not automatically available on Breeze.
Okay, thank you.
All right, thank you. Next, we have Heidi Rothim. Hold on just a moment. We're going to send you a request to unmute your microphone. All right, let's try a second time. Heidi, we're going to send you a request to unmute your microphone.
Thank you. Here I am. Can you hear me?
Yes, go ahead, please.
Thank you so much for having me. I'm a member. I have not participated in any of these meetings, and I really appreciate the discussions here and the level of professionalism and expertise on such challenging issues. There are two issues. Of course, the board is charged with protecting the consumers, and there was that thoughtful conversation. And then the whole other issue as how we as professionals can be safe also, given both personal and professional drivers. And certainly those who are, there are different levels of high priority of who are targets. And I'm not going to rehash the conversation, which I am in wholehearted agreement with in the spirit of why this is coming to fruition. But I think the larger question is, how do we keep ourselves safe also? So I worked in law enforcement for a long while and did a lot of scars on probation officers, people holding guns. I had no protection. I still don't. I own a home, anybody can find me. So this is a different issue, and I do not at all mean to dilute this very critical, relevant conversation that I am so glad that we are having. The other point for consideration is, as somebody who used to interview and employ a lot of people working for local government, we were dependent upon searches, so to really see the validity of some of our applicants. So that's another thing of how that information would be obtained, that it would not hurt an applicant, but support those who were seeking safety should this proceed. So that's all I have to say, but thank you so much for listening to me. And thank you all for the enlightenment.
Thank you. Next, we have Dr. Amuz. Hold on just a moment. We're sending you a request to unmute your microphone.
Yes, can you hear me?
Yes, go ahead, please.
I also very much appreciate this conversation and the contrasting pieces of this difficult puzzle to solve. Very, very important points. I think we're all in agreement that it's very, very important to protect the consumer, but also the provider at the same time. And I was wondering, this is a little bit of a naive question, maybe, piggybacking on what Dr. Winkelman said. Would it be possible, and how and what type of language may be added to this bill to be able to achieve both areas of effort to protect both cohorts that we're talking about here? Would that be possible to add language to the bill? What would that look like? For example, a consumer who would be able to contact the board and ask about information that is then redacted, but would give them the information they need, also protecting the provider and their name or gender change on the records. Would that be possible? I'd like to kind of think about a compromise that we could do to solve this difficult situation.
Thank you. Next, we have Richard Lewis. Hold on just a moment. We're sending you a request to unmute your microphone.
Hello?
Hello, go ahead, please.
Yeah, like others, this is the first meeting I've attended. But what I want to say is I think it's not a hard thing to have a different process in place for licensees with disciplinary action on their record, as opposed to the vast majority who don't. So that's all I wanted to say. Thank you.
Thank you. All right, we're going to do a last sweep for any new requests. And I believe those are all of our requests for comments at the moment. Do you wish to return to the motion?
Yes, thank you so much. So coming back to the board, we have a motion and a second. Dr. Phillips, can you repeat your motion so everyone knows what we are voting on?
I think my motion was that we oppose the statute as the proposed statute as written, recognizing its laudatory purpose, but enumerating the reasons that we have spoken about here today as to why this appears unworkable as it's currently written.
Ms. Sorek, is that a good motion for you?
That was in accordance with my notes on the motion. Yes.
Okay, it's with mine too. Any other board comment before call for the vote? Mr. Fu.
Thanks, Madam President. The comment I just wanted to make was that I think there's a world where you can have both the consumer protection pieces and the intentions of the bill. I think Dr. Phillips called it laudatory intentions, and I think I'm just concerned that an opposed position without any language around oppose of amended or support of amended would signal to the specific issues and intents, the intent of the bill. And so that is just what I wanted to share here, because I think how we convey our feedback and the importance of making the required administrative changes that are absolutely necessary to protect consumers. I think they can be done in a way that opens the door for conversation, that opens the door for this potentially becoming a 2-year bill, that opens the door for a collaborative effort to really address the issues raised before us with regard to gender identity. And so that's so I just would urge a consideration of something that does not show us as like just saying no group of folks, but as a group of folks who have legitimate concerns about consumer protection and are really interested in advancing an idea that works for both the consumer boards, because I think language matters and so do actions. And so that's something that I just want to leave with.
Thank you, Mr. Fu. I think Dr. Phillips raised his hand as soon as you started talking.
You know, I agree with Mr. Fu. I would like to send the message that we are very much interested in advancing this concept. I just think this is a concept in need of a process and a more thought through proposal as to how it's to be done. And I think the statute as written subsumes a lot of people who are getting divorces and getting married and have made a decision to change their name, whether for a nefarious purpose or not, which I don't think is necessary to the purpose of this bill. So I think the bill in so many ways is so overbroad and answers so few questions that the reality is I think we should take an opposed position, but make sure that we make it clear that we're encouraging of the concept as it relates to transgender folk.
Ms. Sorick?
In hearing the most recent discussion, I want to add another piece for more fruitful input, possibly. And that would be a suggestion to the sponsors of the bill to convene a working group with the department and the impacted boards so that we could have the Breeze folks, we could have the policy folks, individuals from the legal office, and really flesh out how this policy would be able to work. It feels like the cart before the horse. So perhaps if the sponsors convened a working group of the stakeholders, being the boards that are going to need to be part of the details on this, that might be a helpful constructive feedback as opposed to a simple opposed. I just want to throw that out for possible consideration.
Dr. Phillips, would you like to amend your motion?
So what would that look like, Ms. Sorick? So we'd be neither opposing nor supporting. We would be suggesting having a working group?
Actually, if the board still wanted to oppose the current vehicle because there are some logistical or detail concerns, then the suggestion would be for the sponsor to consider doing the work group and taking a little extra time to work out all the fundamentals.
So would we include that in an opposition letter? Is that what you're suggesting? I'm confused.
We could, yes. If that was what the group wanted to do, I was just adding that in to be mindful of some of the support of the intent comments that we've heard in the discussion today.
I think it's a great suggestion. So I'd like to amend my motion to include a suggestion to the sponsor that a working group be convened of the various impacted agencies, individuals, governmental organizations, et cetera, so that we can better elaborate a way to make this concept work. So let me just say, the amendment would be to invite or to suggest to the sponsor that he convene a working group to resolve issues. Who's my second?
I am. This is Dr. Harpsheets, and I would agree with that.
Okie doke.
Okay. Since we have amended, I'm going to take the board comment. We have to open it up for public comment again. So is there Dr. Kasuga? I see your hand up.
Thank you, Dr. Tate. I like the suggestion of a working group. As I was looking at the bill analysis, it seems like other boards have figured a way to implement it in their own boards to achieve both be able to provide consumer protection and be understanding of people that would need a name change. So yeah, I just wanted to kind of like echo that I like the idea of suggesting a working group to work out the issues with regards to implementation.
Thank you for your comments, Dr. Kasuga. Mr. Fu?
Thank you, Madam President. I just, since you're opening up the world for amendments to your motion, I just would urge Dr. Phillips and Dr. Harpsheets having an opening in your motion with regard to the position that actually does suggest an interest in a working group. I think when you say you oppose a bill, but you would like a working group, it doesn't quite sound like an invitation for collaboration. I think a position where you have unless amended position, dare I even suggest a supportive amended, recognizing that there probably isn't enough energy around that. I just do urge that that the makers of the motion consider and oppose unless amended with the working group, so that it is actually signaling that the board is interested in working with folks, not just opposing with the bill.
You are correct, Mr. Fu. I have opened it up for amendments. Dr. Phillips?
I think that intention can be conveyed in the letter. I think there's so many amendments that would be required here. It would be kind of counterproductive to list every possible amendment that would need to be made, including the scope of the bill. So I think it would be better for us to take the opposed position and leave the motion as it is.
Okay. Mr. Fu, is that a lazy hand or?
It's a young, lazy hand.
Okay, got it. Okay, I do not see any more hands from the board. I'm going to open it up for public comment.
As opposed to my old lazy hand, is that what you're saying, Mr. Fu?
Don't date the hands.
Dr. Tate previously asked old or young hands, and so I just wanted to clarify for her that it was, in this case, it was a lazy young hand.
Mr. Moderator.
We are now accepting public comment on the matter. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of the screen and send that comment to all participants. Dial-in users, please dial *3 to raise your hand, and we will call on people in the order we have requests. And I believe our first hand was from Dr. Amuz. Hold on just a moment, please. We're going to send you a request to unmute your microphone.
Yes, can you hear me?
Go ahead, please.
Yes, thank you. Wonderful conversation. I'm not sure about the list of amendments and how complicated that would be and the procedural part of it. But I think that we can find a way to convey our support of people who've changed their names and who are particularly in the transgender group, that the spirit of this bill should absolutely be preserved, while also on the other side being able to preserve the rights of the consumer. So not exactly sure. I'm sure that you can come up with some great language though for that. And the work group sounds like a great idea. I feel very relieved at this. I think it's sharing this information with other entities as well could be really productive. So thank you so much for pursuing this train of thought, this path. I think it's very, very beneficial for the process.
Thank you. And next, we're going to call on Dr. Connie Sacco, followed by Jennifer Alley, hold on. Dr. Sacco, we're going to send you a request to unmute your microphone.
Good afternoon. My name is Dr. Kareen McIntosh Sacco. I am a licensed clinical psychologist. I'm also a licensed marriage and family therapist. I've been practicing in the mental health field for, 20 years now. I also have the distinct honor of serving as president of the Sacramento Valley Psychological Association. And it is our local chapter of the California Psychological Association that brought this to CPA's attention due to a handful of our members who are licensed clinical psychologists receiving harassment and discrimination because of how the current process is with the dead naming being so accessible on the Breeze system. And it really does, I'm so grateful for this conversation that we are where we are, that after years of trying to come up with a procedural or administrative way of handling this, we're now at a place where it can be codified in legislature to protect not just the consumers, but also the professionals. And I think a work group would be a great idea. I don't know if it's already been stated, but there are a number of groups that have been working on this, such as the great work by the California Psychological Association, the California chapter of National Association of Social Workers, the California Association of Marriage and Family Therapists, the California Behavioral Health Agencies, a number, because this doesn't just affect psychologists, although I know we are here at the Board of Psychology, which brings me to my next issue about the need to protect our professionals in the current climate that we are in and the current workforce crisis that we are facing, where only 1/3 of Californians can receive the psychological care that their mental illness requires for them. I think it behooves us to do what we can to protect and retain and also make our field attractive for other people to come. So I do think that there is a business point to having the BOP support this measure as well. Thank you so much for allowing me the time to participate. Thank you.
Thank you. And next we have Jennifer Alley. Hold on just a moment. We're sending you a request to unmute your microphone.
This is Jennifer Alley again with the California Psychological Association. I do appreciate your time and your willingness to allow me to give comments for a second time on the new motion. I think this has been a very thoughtful discussion. There's a lot of conversations going around on with this bill, and the Senator's office has been working with the Department of Consumer Affairs, legislative offices, trying to come up with a process for Department of Consumer Affairs to ensure that this will work. And I think that we're all open to having a conversation about how we can balance consumer protection and the rights and privacy of licensees under the Department of Consumer Affairs. It just is such a critical issue. So again, I want to thank you for your time and for your discussion today. And again, encourage you to consider, maybe supporting the bill in concept and requesting a working group rather than opposing this very important measure. Thank you.
Thank you. And we're going to do a last sweep of our comments section here. And it looks like those are all of our requests for comment at the moment.
Thank you. Can we return to the agenda? Perfect. Thank you so much, Mr. Moderator. So we have a motion and a second. Any other board comment before we take the vote? Mr. Fu.
Thanks, Madam President. I just want to say I really appreciate the interest in having a work group. I just can't support an opposed position that doesn't leave open a door for a path forward and signaling an invitation to be open to how to make this bill work. But really appreciative that there's a Ms. Sorik's suggestion for a collaborative work group, and hope that the collaborative work group is able to overcome the objections of the board. So thank you, Madam President.
Thank you, Mr. Fu. Any other board comment? Ms. Pruteau, can you please call the roll?
Thank you. Kasuga.
Aye.
Fu.
No.
Harb Sheets.
Aye.
Phillips.
Aye.
Riscate.
Aye.
Rogers.
Aye.
Tate.
Aye.
Thank you.
Thank you. Motion passes. Let's take a little bit of a break and come back at 3:55. Thank you. I have it as 3:55. Ms. Pruteau, can you call the roll?
Kasuga.
Here.
Fu.
Aye.
Harb Sheets.
Here.
Phillips.
Aye.
Riscate.
Here.
Rogers.
Here.
Tate.
Here.
Roll is complete.
Perfect. We still have a quorum. And let's jump right back in. Agenda item number 4. B5, SB 373. Mr. Polk, please.
Yes, thank you. All right, this is the last action item. The requested action is for board members to review the bill analysis and proposed bill language and consider a position on the bill. Senate Bill 373 would prohibit the board from disclosing the full address of record, also known as the AOR, on the Internet of licensees and registered psychological associates. The bill would allow the board to only disclose the city, state, and zip code of the address of record. The bill was amended on March 23rd to include the county in the disclosed information. So now it reads city, state, county, and zip code. The amendments also added language that states that the proposal would not apply to secondary documents linked to the board's internet website, which may contain the address of record. A hearing is set for the Senate Business and Professions and Economic Development Committee on April 10th. I'm open for questions or comments.
Any board comment for Mr. Polk or any comments in general? Who's this?
I have a question.
Dr. Phillips.
My understanding at this point is that the licensees have to give us either an office address or an alternative address, and they can use their home address if they so choose. Are they obligated to use the home address on the website?
If a licensee wishes, they also may provide a PO box if they do not wish to add their resident address.
So they're all required to use residence address as opposed to office address, or?
Oh, no, I'm sorry. No, if the address of record should be the office address. However, if they are providing telehealth and they are operating out of their residence, if they wish to, they can choose to get to attain a PO box and list a PO box instead of their residence.
Okay, thank you.
Yes.
Any other questions? I have my own comment is how would people do written requests for records? It's my main concern, but let's see what Dr. Harb Sheets has to say.
I would like to make a motion that we support this bill. Is there a second?
I second. This is Shakanda Rogers.
I'm looking for any other board comment? Dr. Phillips?
Yeah, I really think this is placing, and I understand the safety concerns about our licensees, and I have safety concerns of my own. I do criminal forensics as part of my practice. So I don't want people to have my home address. But I've never listed my home address. There was never been a reason to. I've actually used a private mailbox. I think there are ways for people to get around this that they can protect themselves without denying consumers the way to be able to contact their past or present psychologist by mail. For instance, if you want to get a copy of your records, you're required to submit a written request with your signature. As far as I know, that doesn't necessarily contemplate you do that by email, and we don't include email addresses as it is anyway. So I think people can use either an office address or a PO box, which they can do at fairly low expense, to provide themselves with that protection without denying consumers a way to contact the therapist and to know where their therapist will receive mail. I don't get it. Is it that people object to having to spend a few, $15 a month to get a PO box? There's lots of ways to protect yourself, but it doesn't necessarily require cutting off the consumer from a means of contacting their therapist, whether for a legal or other purpose.
Dr. Harp-Sheets.
I don't read this as cutting off the consumer. There will be some address of record. It just won't be their home address. So wouldn't there still in the record online be like a PO box or some way to contact them?
Nope, it'll be a listing of what city they're in, what county they're in, what state they're in, and their zip code.
There's no listing of the address. You can't write to your therapist.
I got to think about that. Okay. So if I am a consumer and I would assume if I would know how to reach my therapist because I've been to their office, unless they're telehealth only. So,
or it's years past. Maybe you need records from 8 or 10 years ago and they've moved offices. And I don't know what the procedure would be, but I'm guessing it would look like you call the Board of Psychology to get this information.
You might have to do that. So this protects the psychologist from the information being readily available. That's how I see it.
And it protects the consumers from the information being readily available. The consumer interest should, I think, given that there are safeguards that people can put in place to protect themselves, the consumer should be the predominant concern here.
Any other board comment? Dr. Harp-Sheets, were you about to say something else?
I was just going to say that I don't see, I understand why you're saying, Dr. Phillips, that the consumer interest should be the predominant concern, but it doesn't stop them from getting this information that they would be able to contact the Board of Psychology, that there are plenty of ways to get that information, but my concern was making it so readily available that there should be some protection.
Ms. Sorick, is my assumption correct that these phone calls would come to the Board of Psychology regarding addresses to obtain written requests of records?
Yes. So if, unless they were able to find the person's address by other means, then they would contact the board and get the same information that used to be available on license lookup. I did just want to add, Dr. Phillips mentioned the expense. And I just wanted to note that the U.S. Postal Service put on its website that a P.O. box is as low as $4.50 a month. So there isn't a requirement that an individual put their home address as their address of record. They could choose to use an alternative address.
Go ahead, Dr. Harpsheets. Dr. Harpsheets, do you have a question or a comment?
Sorry, I forgot to unmute myself. We're not talking about the entire group of licensed psychologists in the state. We are talking about people who do not have an office address, who do not list a P.O. box. And so this is not a large group of people is how I see it. And, you know, if anybody else has more information, I would appreciate that.
Mr. Polk, is not having the more specific information contingent on a request from the licensee, or will it apply to all licensees? Mr. Polk, you may be muted.
Oh, it looks like he's muted. This would apply to all, so it wouldn't be by request. It would be that we would not be able to post this information.
So it's a blanket. So it's a blanket for everybody.
It's a blanket for everyone. Yeah.
Is there any other comments from board members? Dr. Harpsheets, do you have any more questions, or would you like to amend your motion?
No, I'm happy with the motion. I'd like to hear public comment.
Okay. I do not see any other board member comment. Mr. Moderator, can you please open public comment?
We are now accepting public comment. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of the screen and send that comment to all participants. Dial-in users, please dial *3 to raise your hand, and we will call on people in the order we have requests. And looking around, I see we have a comment from, I believe, Joanne. Hold on just a moment. We're sending you a request to unmute your microphone. All right, Joanne, we're going to send you another request to unmute your microphone. Looks like you're on a mobile device. Down at the bottom in the center, you should have 2 audio buttons. The left one should be the one that allows you to unmute. And we may have lost Joanne. William Young, hold on. We're going to send you a request to unmute your microphone. William Young, we're going to send you a second request to unmute your microphone. And it looks like William Young is the last request for the moment. So we're going to send a third request to William Young to unmute, and then we're going to move on. Thank you very much. We have no requests for comment at the moment. Shall we return to the agenda? Wait, I take that back.
Oh.
Jennifer Alley, just saw your hand popped up. We're sending you a request to unmute your microphone.
Hello, this is Jennifer Alley. My apologies. I thought I had already typed in comment in there. So the WebEx is always a little bit challenging for some of us. So thank you again, board, for your opportunity to continue the conversation about, this important issue. Again, it's trying to balance the protection of licensees and consumers. And I just want to point out that there are boards that currently do not display the complete address. The Board of Physical Therapy, the Respiratory Board, the Board of Vocational Nurses and Psychiatric Technicians. And so there are some boards of health providers that don't display the complete record on the website. For consumers that would like to obtain a copy of their record, and they need the mailing address, they can call their provider and they can ask for it. Or they may be even able to contact the board directly. This is about what's displayed on the website. And so when we think about the world that we live in, and maybe, there's a psychologist that's been providing services to, a patient that's expressing domestic violence, and they suddenly change or terminate that relationship, then it could be the spouse or the partner that wants to know the address of the psychologist. And so there really is, a lot of risk for our members who may be providing care and treatment to individuals that are unwell, and for just a reduction in what information is publicly available on the website is what we're trying to achieve. And so I appreciate the board's thoughtful discussion today, and I hope that you'll be able to support this measure. Thank you.
Thank you. And it does not appear that we have any more requests for public comment at the moment. Shall we return to the agenda?
Yes, and thank you for your help. There is a motion and a second. Is there any other board comment at this time? I'm going slow. Did someone just try and speak and I missed it?
Oh, that's just me, Dr. Hartsheets. I was just going to reiterate what Ms. Alley had said, that the information is available in other ways. And I just wanted us to be aware that it's not that we're precluding the public from finding the information to contact the psychologist, but it does provide a measure of protection for the psychologist, and I don't think hurts consumer protection in doing so.
Thank you. Dr. Phillips.
I'll keep it brief. I think we're reducing the ability of consumers to get in touch with past or present therapists. I understand people's concern for the personal safety. I would never recommend using a personal address, but there are other means for people to protect their address without denying consumers information, particularly consumers that may have had somebody in the past. As I said, I evaluate a lot of people who are in a very high-risk population, and I'm very conscious of the need for safety on the part of therapists. But I've also chosen a profession that puts me in perhaps more danger than a typical profession. I just think that in this particular situation, the rights of the consumer to easily transparent information should predominate over safety concerns based apparently on not an unwillingness to take other measures that could be equally, keep them equally safe without denying the consumers those protections.
Thanks, Dr. Phillips. Any other board comment before we call the roll? Ms. Pruteau, can you please call the roll?
Kasuga.
Nay.
Thank you. Fu.
Aye.
Harb Sheets.
Aye.
Phillips.
Nay.
Riscate? Once again, Riscate? Rogers?
Aye.
Tate?
Nay.
Okay, we're coming back to Riscate. Let me check this.
I think she left the meeting at this time. So she's not logged in currently.
Okay. So we have...
What's our tally, Ms. Bruto?
We have Kasuga, no, Mr. Fu as an I, Harv Sheets as an I, Phillips as an nay, and Rogers as I, and Tate as nay. So we have 1,
6,
2,
3.
Yeah.
This motion did not pass. Ms. Sorek, do we need to do anything else with this item?
No. We can just continue to monitor the bill, and it'll be on the May meeting agenda.
Perfect. Thank you so much. We're moving on to agenda item number 5. This is legislative items for a future meeting. The board may discuss other items of legislation in sufficient detail to determine whether such items should be on a future board meeting agenda and whether to hold a special meeting of the board to discuss such items. Any board comment on this item or suggestions for the future meeting? Mr. Fu?
Thank you, Madam President. I think just not necessarily for an item for discussion, but for if there is a bill that is introduced related to certain types of psychiatric drugs that psychologists would be able to write, if that can just be added as an issue that to watch if it comes up, that would be really helpful for us. I've in my other role in terms of working in the housing and homelessness space, I've heard this come up on a few occasions now with regard to the shortage of mental health workers, specifically psychiatrists, and there are some physicians who've indicated that they are supportive of having psychologists write prescriptions for certain types of medication, and so just would be curious if it becomes a bill and it is introduced.
You're correct. There is some chatter about that. So kind of just a watch position on that to see if it comes to something.
Yeah, so an issue watch, if you will.
Okay.
Yeah.
Issue watch.
No position necessary.
Ms. Sorek, did you get the issue watch alert?
Yes, we'll make sure that's in our search terminology. And if any of our stakeholders, such as CPA, is aware of any legislation on the horizon, if they could also give us a heads up and let us know, that would be great.
Perfect. Any other board members with items for future meeting? Legislative items. I do not see any hands. Mr. Moderator, can you open up public comment for this item, please?
Absolutely. We are opening for public comment. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of the screen and send that comment to all participants. Dial-in users, please dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take a few seconds now to see if we have a request for public comment. Seeing no request for public comment, do you wish to return to the agenda?
Yes, please, and thank you so much. Moving on to agenda item number 6. This is recommendation for agenda items for future board meetings. The board may not discuss or take action on any matter raised during this public comment section except to decide whether to place the matter on the agenda of a future meeting. Can you please open up public comment, Mr. Moderator?
We are once again open for public comment, this time on agenda item 6. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of the screen and send that comment to all participants. Dial-in users, please dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no, hold on just a moment. Will there be a way to get the time frame attended? I believe we're going to be addressing that soon.
Yes.
All right. I do not see any public comments for agenda item 6.
Thank you so much. So before we go,
Dr. Tate, sorry.
Yes, go ahead.
I wanted to go back to agenda item number 5, if it's possible. I have like a recommendation for something to watch.
Okay, go ahead.
Watch bill. Sorry, I wasn't able to unmute quickly enough. It would be AB 248. It's individuals with intellectual or developmental disability, the Dignity for All Act. And basically, it's to remove terms related to MR and replace everything with intellectual disability. I just want to make sure that if there's anything in that pertains to us with obsolete terms, that we can look into it. So I think that it's relevant to watch if it's possible.
Thanks for mentioning that. Ms. Sorek, did you get that bill?
I did. Thank you.
Thank you.
Okay, thank you, Dr. Kasuga. Before we move into closed session, I'm going to give Ms. McCochran a few minutes to address the CPD. Ms. McCochran. If you're talking, Ms. McCochran, you are on mute. I can't hear her. Is anyone else hearing her? It could just be me.
We do not hear her.
Okay.
She clearly has a microphone attached, but there is no audio coming through.
It looks like she sent a text or a chat, sorry.
All right, hold on.
And I'm happy to read your chat. Oh, go ahead.
Oh, by all means, go ahead.
So Ms. McCochran said, thank you for attending the board meeting. You will receive 6 CPD hours for your participation under CPD category number 1. Sorry, I'm in a little box. For your records, please note today's date as April 7th, 2023, the name of today's meeting, which is board meeting, and 6 CPD hours. If you called in, email bopce@dca.gov with your name and phone number used. Please be advised that the amount of CPD credit you will receive corresponds to the duration. Oops, I lost it. I'm sorry. For the duration
of your attendance.
If you do not stay for the full duration of the meeting or were late, the amount of CPD credit you will receive will reflect the time you were present. It is important to note that attending a meeting for 3 hours or less will result in hour-for-hour credit, while attending for the full day, more than 3 hours, will credit 6 hours. We appreciate your dedication to professional development and look forward to your continued attendance, participation, and future events. So thank you, Ms. McCochran, and I'm sorry that we could not hear from you directly. As for everyone, the board will meet in closed session to discuss disciplinary matters, including petitions for reinstatement, modification, or early termination, proposed decisions, and petitions for reconsideration and remands. We will only be coming back to open session after closed session is completed to end the meeting for today. Thank you so much. And all board members stay on the call. Thanks to everyone for attending today. We appreciate it.
Oh, real quick, before everybody leaves, I just wanted to mention that the EPPP Ad Hoc Committee will be meeting on April 28th to discuss examination issues. And then the next board meeting will be May 19th, also WebEx. So we look forward to seeing you all there. Thank you.
Madam President, unfortunately, I had scheduled an appointment, assuming we were going to be done by 4, so I apologize, but I will have to leave the meeting now.
Okay, thank you for letting us know.
Okay, talk to you later.
Have a good weekend. Thanks.
You too.
Okay, I'm about ready to start the closed session, which in WebEx, they lovingly refer to it as the practice session. So let's start by looking at our panelists and determining who needs to be removed from the panelist list. Is someone available to help me?
Oh.
Go ahead, Dr. Tate.
Oh, well, I'm here. I'm looking through the list.
Oh, okay.
Stephanie's supposed to stay. Yep, everyone there. Alex shouldn't be there, correct? And Brittany stays.
I think we can.
And Sarah, are you staying? Oh, no, I don't think Sarah stays.
Oh, I thought you said Saron. Yeah, Saron's here.
No, Sarah's good.
No, I'm going to leave. I was just making sure that everything is taken care of before I leave the session.
Okay.
All right. Take care.
Thank you. So I have Brittany and Stephanie, and then the rest are all board members.
But Leah, we still have 56 attendees.
Well, he was just asking about the panelists.
Oh, okay.
So I just removed Sarah from the panelist list. And what other names were stated?
Well, I see under attendees it says 57, and if you click on that, there's a lot of different people.
I understand that they are going to be excluded from the discussion.
We're only talking to panelists, and so Stephanie's here, and Brittany, and you, and so then yeah, that looks good to me. Is anyone else?
So besides myself, everyone else is staying?
Yes.
Okay. Who is going to take control of the meeting?
Stephanie.
Me.
All right, Stephanie. I am going to start by giving you some power, and then we're going to start moving things over. Did I just lose Stephanie?
Yeah. She is not. Yes, you did. She's not on the panelist anymore.
Well, that's unfortunate. Hang on just a moment, please.
If we need to,
She's on the attendee list. She
She
said.
just got promoted.
All right.
Okay.
So,
I'm back.
welcome back.
Dr. Tate, some of the folks in the chat are asking about, will there be a record of the time frame that they can receive? And I think you had announced 6 full credits. Is that correct?
6 credits if they stayed for 3 hours. If they were less than 3 hours, it's 1 for 1.
Got it. Okay. Hopefully everyone heard that.
Okay. I was gonna say you can respond with that, but I don't know if you want to. But Lizelle put that, I was reading it out of the chat. Like I was literally just reading.
Okay. So at the moment, we have paused recording, and I am going to take us into our practice session. Oh, I cannot anymore because I gave Stephanie the power. Stephanie, in your drop-down menus, you have your third from last is called webinar.
Okay, found it.
And you see start practice session. And hear what is going on.
Perfect.
And you might want to hit record if you want to record this adjournment.
Oh.
At the very bottom in the center.
Is that the recorder with the yellow circle?
Yes, exactly.
Okay, I'll click that. And then I'll hit resume.
Yes, please.
This meeting is being recorded.
Hello, this is Leah Tate, and it is 5:16 p.m., and I am adjourning the Board of Psychology meeting for April 7th. Thank you.
Thank you.